done us proud to the family and even otherwise to the entire co-partnery of lawyers and judges. Thank you so much for being with us to make the concluding remarks in this particular session. The resource person for this particular session is Dr. Sudhir Jain. If we had this particular workshop the next weekend, I would have introduced him in a different manner. We are looking forward to that happening in the coming week. Dr. Sudhir Jain has played his innings at the district level since the year 1992 and is presently the district and session judge in Northeast Delhi. Made rich contribution, but he stands tall as a stalwart in the domain of mediation. He has participated in more than 12,000 cases in resolving them. 100 training programs he has conducted. We couldn't have thought of a better person to enlighten us in regard to the role of mediation in resolving the family disputes. May I request Dr. Jain to make his presentation and enlighten us in this particular regard. Over to Dr. Jain.
Thank you, Dr. Balram K. Gupta and Honorable Mr. Justice Vikas Bahl for giving me this opportunity. First, I would like to extend my sincere gratitude to Chandigarh Judicial Academy for giving me this opportunity to be the part of this amazing workshop for the family court judges. My relation with Chandigarh Judicial Academy is not new. In this place, I have conducted more than 10 programs on concept of techniques of mediation for judicial officer, for advocates and others. So I find myself is a very honored person for this program. As Dr. Balram K. Gupta, director of this academy, has mentioned, the use of ADR, particularly mediation in resolving matrimonial dispute. Dear friends, I have started my practice in the field of mediation somewhere around in 2003-2004. Since then, I am regularly doing the mediation, particularly in the matrimonial and family dispute. What I have found is that mediation, a part of ADR and Section 89 CPC, is a wonderful, amazing technique to resolve the matrimonial dispute and family dispute to the satisfaction of the parties, forgetting the hostility of the adversarial litigation. In my talk for 1 hour on the introduction of the mediation in a matrimonial dispute, I would be talking about that one thing before introducing the subject, that the entire matrimonial litigation, whether it is subjected to the adjudication or whether it is subjected to the resolution, is nothing but it is the management of the perception of different parties. First, we need to understand what is the perception and how the perception is the genesis of the conflict and how the conflict can be resolved, and then mediation as a technique, and then use of mediation in resolving matrimonial dispute. I shall be sharing my short PowerPoint presentation for the benefits of the participant. This is visible on the sir, whether this slideshow is visible on the screen?
I can see.
Okay, sir. Thank you, sir. For matrimonial dispute, first we need to understand what is conflict. It's a very good quotation. It is easier to perceive error than to find the truth, for the former lies on the surface and is easily seen, while the latter lies in the depth where few are willing to search for it. As you know, we are all judicial officer, and the search for every judicial, the quest of the every judicial process is to find the truth. To find out the truth, particularly in a matrimonial dispute or family dispute, we need to go deep inside the dispute, because truth is always found in depth, while the other things, they are lies on the surface. What is perception? Dear participant, do you agree with this? My quotation, everyone has two eyes, but no one has the same view. This we experience in the matrimonial and family disputes. Circumstances are the same, but how the husband and wife and other family members, they are perceiving the conflict or the factual background is entirely different. For wife, the dispute is entirely different, and for husband, the entire dispute is entirely different. So for in our life, the perception is very, very important. If I ask very a simple question to give you the idea what is perception, if we need to offer one seat and that there are four claimants, a lady with a child, an old lady, an handicapped person, and if fragile and a very ailing young man or man, to whom you would like to give or offer your seat. Some of you would answer A, some of you would answer B, some of you would answer C, some of you would answer D, depending upon to whom you would like to offer your seat. Why? Seat is one, but the claimants are different, and why you are preferring the different claimants? It is because on the basis of your perception. So what is the perception? Perception is how we receive any stimuli, that is the factual position, how we are interpreting that stimuli, and how we are giving meaning to the response or stimuli we are receiving. Dear friend, you would agree that our perception vary from persons to person. It is not for the same. If I ask the benefit of the workshop for family court judges, dear friends, you would like to give me a different answer. Workshop is the same, curriculum is the same, resource person are the same for all the participants, but your responses would be different because our perception vary from person to person. And different people, this is 100% true in case of matrimonial litigation. The different people perceive different things about the same situation, and they assign different meanings what they perceive. You know, matrimonial dispute, whether they are subjected to adjudication or resolution, when we interact or encounter with the different person, they perceive and they assign different meaning to the same situation because of their own perception. So now, when we are dealing with the matrimonial litigation or family litigation or dispute, we need to understand the difference between perception and the reality, and the entire journey of any adjudicatory mechanism or resolutory mechanism is taking the parties from perception to reality, right? Our perceptions may be based on knowledge, needs, beliefs, values, assumption, and most important is our attitude. If you ask, there is some questions from you, you will be giving me the different answer. Suppose I ask, there is a dispute between father and son. Son is getting late every day to reach his educational place. He is asking from his father to purchase a motorbike, but his father is very much concerned about the safety of his son and what he considers that it is not safe to drive the motorbike on the road. So he is not ready to purchase a new motorbike for the son. If I ask very simple question, who is right, whether father is right or son is right? So answer would be the different. There cannot be answer that both father and son are right. Either father is right or son is right. It depends upon our perception. You know, entire matrimonial litigation, the matrimonial dispute are nothing but it is the perception management. Now, on the basis of perception, I mentioned everybody has a different perception. I would be justified in my words that in our society, the genesis, the origin of the conflict is our different perception. The conflict, they are the part of our life. They are natural, inevitable, and everywhere they are present, omnipresent. We cannot avoid the conflict in our life. We cannot imagine any day in our life which is without conflict. If we define the conflict, if we say the simple definition of the conflict, it is nothing but it is the disagreement or incompatibility or difference of opinion, or you can say the contest between people with opposing needs, ideas, belief, values, or goal, like father and son. They are having the different ideas. They are having the different beliefs and values. So they are having the conflict because of their different perception. Now, dear friends, if you agree, no conflict is good or no conflict is bad. But if a conflict is resolved, it is addressed properly, it can be resolved, it can be minimized, it can be diverted. If the conflict is allowed, like the matrimonial conflict or matrimonial dispute, if they allow to grow, if they allow to be continue, they may fracture relationship, they may escalate non-productive results. So every conflict, including matrimonial conflict, is required to be resolved beneficially. If we address the conflict in the right perspective, in the right direction, the quality final products may be achieved. In matrimonial cases, most of the time, the dispute is regarding the payment of maintenance, permanent alimony, and other expenses. How this can be addressed? Most of the time, we address kitna dega, right? But conflict resolution is much more beyond this simple compromise. So that conflict is always an opportunity in disguise where we can find a different, very productive result also in matrimonial case. To handle the matrimonial dispute, family dispute, we need to understand what is conflict, what is the perception of different parties who are standing before you, how they are perceiving the situation, the matrimonial situation, or other factual background, factual situation, which is the genesis or original or originate of the conflict between husband and wife and other family members. We need to manage after understanding the conflict, we need to manage the conflict. How we can manage the conflict? If we are able to handle conflict sensibly, fairly, and efficiently. Dear friends, I remain posted in family courts for more than 3 years. And I'm telling you the best part of my judicial career posting in the family courts in 3-4 different districts. I could manage to learn how to understand the conflict on the basis of different perception, and then how to handle the conflict sensibly, fairly, and very efficiently so that I can resolve the conflict. Because of this, on my judicial side, in my mediation work, I managed to resolve number of hundreds of matrimonial disputes. We need to also understand when the conflict is there, when the husband and wife, they are standing before you in the court, how they are responding to the conflict. Their responses may be different. They may be avoiding the dispute or maybe conflict. There is a little bit difference between conflict and dispute, but I'm not going into that extent. Avoiding, sometimes the parties, they preferred not to acknowledge the dispute or conflict between them. क्या झगड़ा है? कुछ भी झगड़ा नहीं है. Sometimes the parties, they are in the adopt accommodating approach. What does it mean? If wife is asking rupees 10 lakhs for permanent settlement, the husband is readily agreed to pay rupees 10 lakhs. If husband is ready to pay rupees 3 lakh, then wife readily agreed to accept rupees 3 lakhs without any confrontation, without further litigation, or without any further dispute. This is accommodating. Sometimes the parties, they are competing, they are sticking to their position. You must have experience when you are making efforts for settlement in the court. Sometimes the husband is saying, I'm not ready to pay more than rupees 3 lakhs, and wife is saying that I will not accept less than rupees 10 lakhs. Both of them, they are sticking to their position. So this is competing, but why avoiding, accommodating and competing? We cannot resolve the dispute. We cannot address the parties in mediation, because parties, They are not in the compromising or collaborating mood. In all this approach, either one of the party is benefited and another party is loser. Another approach is like the compromising, where the parties, they sit together and they find some common solution, a midway solution. If husband is ready to pay rupees 3 lakhs and wife is asking rupees 10 lakhs, so generally parties settle for 5 or 6 or 7 lakhs. But this is compromising. But in mediation, in dispute resolution, when we start our journey from dispute adjudication to dispute resolution, from confrontation to cooperation or collaboration, the next stage is collaboration. When parties approach collaborating approach, what does it mean? When husband and wife sit together, husband is saying, I can understand that my wife needs rupees 10 lakhs, and wife is saying, I understand that my need is rupees 10 lakhs, but my husband cannot pay more than 3 lakhs. So they sit together, they find some collaborating solution, like that sharing in the property, sharing in the profit in out of the business being run by the husband or any other way. So in handling the matrimonial dispute by the mechanism of ADR or particularly mediation, we need to adopt compromising approach or collaborating approach. Right, sir? Then how the conflict can be resolved? There are the various ways, but देखिए कितना, it's a very good quotation. Running away from any problem only increases the distance from the solution. The easiest way to escape from the problem is to solve it. When a matrimonial dispute is before us, a family dispute is before us, we need to address the problem, we need to address the conflict so that we can find a viable solution which is acceptable to both the parties. Every conflict starts like a spark of fire. What I've experienced, if it is not addressed in right and proper perspective, it can blast like a volcano. Right? I'm coming to a detailed definition of mediation and what does mediation is all about. But in the process, when we conduct the mediation, how we resolve the conflict, we gather the information. Like when a plaint is presented before you, it is the perception of either of the spouse. When a written statement is filed before you, it is the perception of opposite party. So when we read both petition and written statement or counter affidavit or counter reply, we can know the factual background of the dispute or what are the underlying interests of the party, that is gathering information. Thereafter, we identify the problems and thereafter we create the problem and convert the one options into the potential settlement. Like just I have given one example to you. If I ask how you would like to resolve the problem between father and son, many answers can be given, like the underlying interest of the son is to reach at his school within time so that his study should not suffer. And the basic concern of the father is the safety of the child. Many solutions can be found out that the father and son can shift to a place which is situated near to the school of the son. The father can purchase a cycle, he can arrange a pool car, he can arrange a taxi, he can arrange a cab, or any other solution can be found out. And one solution after proper evaluation can be converted into the potential settlement or mutual settlement. Now, with this little bit background, what is perception, what is conflict, definition of conflict, how the conflict can be managed after understanding the approach of different parties to the conflict, and then thereafter, after managing the conflict, how the conflict can be resolved. But what is matrimonial dispute? Dear friends, why the marriages are required in our society? The marriage enables couples to settle down in their life and to live peacefully. The basic philosophy, basic theory behind it is a social requirement for the continuity of the species. But sometimes the little quarrels between young couples assume serious matrimonial dispute. What I have experienced in my career as a matrimonial judge, in most of the case, only there is a little bit difference or little bit conflict the normal wear tears of the life, they get mature into the matrimonial dispute because they were not addressed, they were not corrected at the appropriate and right time. Because of this situation, there is outburst of matrimonial dispute. But you will find there are many reasons for matrimonial dispute. Domestic incompatibility, competition for economic and social resources, sometimes emotions, ego, social compulsion, personal responsibility, various social multiple factors, they are involved and they are basic cause of matrimonial dispute. Earlier, if we experience out of our past experience, earlier the matrimonial dispute were resolved by the intervention of elders. But now most of the elders, they are also involved, they are also dragged into the matrimonial dispute. So they are not available. It may be the nuclear family may be one of the reason. But dear friends, our matrimonial dispute, they are required to be resolved amicably by mutual agreement. We need to make efforts for amicable resolution of dispute. In every case, our endeavor should be, before passing the judgment, a contested judgment on the merits of the case, we need to make our positive and sincere effort for resolution of disputes. I just mentioned there are a number of causes for genesis of matrimonial dispute. The origin of matrimonial dispute may be the ego and pride of the parties, husband and wife, their behavioral disorders, different perception, self-interest of the parties, incompatibility, psychological problems, adjustment, expectation, even sometimes the medical reasons also. And I was reading one article and I don't know how far it is correct or not, but what was mentioned in that article, the 6% of the matrimonial dispute are because of the use of section 498 IPC. How the mediation is effective in matrimonial dispute? What is mediation? First, we all of you are the family court judges. The basic jurisprudence of the family court, the basic philosophy and theory is, as per the preamble, the family courts were established with the objective of amicable settlement of matrimonial dispute. In the spirit of the Family Courts Act, our first endeavor must be the amicable settlement of matrimonial dispute. The Law Commission in 59th report speaks for creation of courts concerning the family dispute with simplified procedure. Right? Family Court Act 1984 was enacted for speedy disposal of family dispute and to promote conciliation and settlement. Now, it recognized conciliation. The Family Courts Act, it recognized conciliation because as per the section 89, mediation, conciliation, lok adalat, judicial settlement and arbitration, they are different ways. So conciliation is little bit different from mediation, right? It's a minor difference, technical difference only. Otherwise, mediation and conciliation, more or less, they are similar. The Family Courts Act recognized conciliation for settlement of matrimonial dispute or by reconciliatory processes. Conciliator, in the family courts, the number of conciliator or counselor, they are attached to encourage the parties for resolution. We know the section deals with the duties of the family court to make efforts for settlement, and it to adjourn the case if there is a possibility of settlement. Now, section 89 deals with resolution of dispute by ADR, including mediation. Now, emerging as a effective, this mediation, very effective and workable mechanism for dispute resolution, it is also recognized. Mediation now, very efficient, speedy, convenient and less expensive remedy for resolving the family dispute. Dear friends, in Delhi, we have settled more than 2 lakh cases, including family dispute and matrimonial dispute, by the process of mediation. What is mediation? Mediation is entirely different from the judicial process. What does it mean? What we are doing in the court. Mediation is a very voluntary, flexible, non-adjudicatory. It is very important. It is party-centered process. Mediation is voluntary, flexible, and party-centered and very structured negotiation process. It involves a neutral third person. Who is neutral third party? Is a mediator. What the mediator does in the mediation? He facilitates. Mediator does not decide, does not adjudicate. He did not talk with the parties on the merits of the case, but he allows the communication. He used the bargaining and negotiation to bring the parties to amicable settlement, which is developed by the party themselves. The mediation, very important, is it retain the right of self-determination. What does it mean? In judicial process, ultimate decider is the adjudicator, that is the adjudicatory authority, that is judge or judicial officer. The judge or judicial officer, after considering the case on the merits, evidence led by the parties, documents and pleadings relied upon by the party, the judge or adjudicatory authority decide who is right, who is wrong. But in the mediation, the parties sit together, they talk with each other, they negotiate, bargain, develop many options, and ultimately for final settlement, the parties, they are themselves responsible for the right of self-determination to find out the final solution of their conflict, whether they are living together and whether they prefer to separate from each other. And one thing which is attached with the mediation process and which is required in matrimonial dispute, it is confidential. A mediator is not obliged what was deliberated or negotiated during the mediation before the court. A mediator cannot be called as a witness in the court proceedings. Mediation is not covered by procedural rules, but simultaneously it is not casual, very effective remedies. In this mediation, you will find the factual position, legal position, the underlying interest of the dispute parties in a dispute, they are addressed. We ask the parties to sit before the mediator, start communication, start bargaining and negotiation, develop many options, and then convert one option into the settlement. Ultimately, out of the mediation, what is developed? A mutual acceptable solution which satisfies needs and interests of the parties. Dear friends, I will give you one example. It is not a matrimonial dispute, but it was a labor and management dispute. How it was a very effective remedy. Mediation is very effective and very creative remedy. In one case which was referred to me for mediation, the workman was terminated from the service. He raised industrial dispute. The case was referred for mediation, and by that time the workman has expired. His wife, his two sons and daughter, they were brought on record. The opposite party, that is management, was a well-reputed school of Delhi. During the mediation, what I noticed that the wife of the deceased workman was not able to provide good education to her daughter, who was good on study. She wanted to continue with her study, and management at the end of the negotiation has agreed to provide free education to the 12th standard, up to the 12th standard, to the daughter of the deceased workman. So this kind of creative and very positive a solution we are able to find out, which are a solution which are acceptable to both the parties, which bring win-win situation for both the parties. In mediation, particularly in matrimonial dispute, we address the emotions, sentiment, social compulsion responsible of the parties, which is very unique to the nature of matrimonial laws. In adjudicatory process, in judicial process, we hardly address sentiments and emotions of the parties. Matrimonial mediation is entirely different from other dispute like commercial dispute, property dispute, and personal injury dispute, MSCT or labor management dispute. I just mentioned, as per the Family Court Act, the conciliation is the basic remedy, but if parties they are not able to settle their dispute with the help of counselor or conciliator, even the remedy of the mediation is still open. the matrimonial dispute can be resolved to the satisfaction of the parties despite failure in mediation or in conciliation. Or I'm telling you, the mediation, it resolves the wide range of matrimonial dispute. On adjudication side, if we are dealing with 125 petition, if we are dealing with divorce, custody or restitution of conjugal right or any other dispute between husband and wife and family member, we would be deciding only that part of the dispute between the parties. But once the case is referred for mediation, we discuss the entire range of matrimonial dispute involving the divorce, permanent alimony, permanent maintenance, custody, visitation right, FIR, questioning of FIR, and other dispute pending between the party, that is past, present, and future jurisdiction relationship we address in the mediation. You know, after mediation, what is mediation? How it is important in the matrimonial dispute? Like I was referring the role of adjudicator while sitting on the dais and role of the mediator. In mediation, the role of the mediator is entirely different. A mediator is entirely different when he's handling the commercial of any other dispute. The primary role of the mediator in matrimonial dispute, in matrimonial mediation, is facilitative and non-judgmental. We hardly decide on the merits of the case like as we decide while sitting on the dais. We only facilitate. We guided the party. We used to guide the parties towards the settlement. We did not dictate. As a mediator, I never dictate any terms and condition of the settlement to the parties. The parties themselves, they develop the terms and condition of the settlement. Now, one question as a referral judge, while holding the case, holding the matrimonial court, I know in state of Punjab and Haryana, we have conducted under the aegis of Mediation and Conciliation Project Committee, the Supreme Court of India, we have conducted number of training programs for advocates and judicial officers to train them as a mediator. I hope and every reason to believe in every district in the state of Punjab and Haryana, the number of mediators must be or they should be available. The mediators are there. If you cannot do the mediation while in your judicial capacity, but we can refer more and more cases for mediation, matrimonial dispute for cases to the mediation. But next question, very important, at what stage the case can be referred to mediation? You know, as per the AFCON judgment, which was decided by the Honorable Supreme Court in year 2010, the judgment delivered by Honorable Mr. Justice R.V. Ravindran and Honorable Mr. Justice J.M. Panchal. This case, AFCON judgment, very famous case, deals with the various aspects of the mediation. In this case, the Honorable Supreme Court has considered about the suitability of cases for referral and by on the basis of summary and nature of dispute. In matrimonial dispute, what the Honorable Supreme Court has mentioned, कि these cases must be referred after service of notice on the opposite party, but before filing objection or written statement to avoid further hostility between the parties. Right? So when we refer a case for mediation, before filing the counter affidavit, counter reply or written statement by the opposite party only to avoid further hostility. Dear friends, try to refer the more and more cases for mediation. I will give you the data of Delhi at the end of my talk, how the mediation is effective in matrimonial cases, right? And one thing is that, which is very important, which was laid down in AFCON judgment, that if you are referring a case for mediation, whatever may be the nature of dispute, maybe it matrimonial dispute, family dispute, or any other dispute, if you are referring a case for mediation, the consent of the party is not required. It is not mandatory. If you consider that this case is suitable for mediation, the parties, they can resolve their dispute. There can be possibility of settlement without even asking the parties. You can refer the case for mediation, even in the absence of consent of the parties. And this is the judicial finding of the Honorable Supreme Court. mediation process, just like the judicial process, like in the criminal cases, the charge sheet is filed, cognizance is taken, accused is summoned, copies are supplied, charges are framed, prosecution evidence, statement of accused, then defense evidence. In the mediation also, the entire mediation process, which I talked just before, how the dispute can be resolved, the mediation process can be divided into 4 or 5 functional stages like introduction. Introduction part is, it is not in practice in judicial process. We also conduct a joint session, both the parties. We also talk individually with the parties, which is also not practically possible in judicial process. Agreement on the terms and conditions which are developed by the parties themselves. It is again not possible on the judicial side, because in judicial side, we are giving the final judgment on the basis of merits, facts, law, evidence brought on record. But agreement in mediation is always what was deliberated, what was agreed upon between the parties. Now, when after conclusion of the mediation, the very important part is the agreement drafting. Agreement is the only mode of communication between the referral court and the mediator, right? If the agreement is not properly drafted, it will not convey what was decided between the parties to a matrimonial dispute or any other dispute. To an agreement after conclusion of any matrimonial mediation proceedings, it must be very comprehensive, it must be clear, it must be concrete and concise. When we draft agreement in a matrimonial, particularly in the matrimonial dispute, we ensure the presence of the parties and as well as their counsel at the time of drafting of matrimonial dispute agreement. Initially, I used to mention the brief facts, not giving blame on each other party. For example, when the marriage was solemnized, when the parties they are living separately, how many children they are having, and their history of litigation, without mentioning what is alleged by the wife, what is alleged by the husband, or what is alleged by any other party. No allegation, no counter allegation in mediation agreement. Like in the judgment, we mention what is alleged by the plaintiff and what is the defense taken by the defendant or respondent or opposite party. But in mediation agreement, we hardly mention this fact. How the parties they prefer to take divorce. In most of the cases, it is always by divorce by mutual consent. When the parties they will be filing their first motion or second motion petition, all these facts are required to be clearly addressed in agreement drafting. Then we also mention how much the permanent alimony is required to be paid by the husband to the wife and children, and the quantum of maintenance also, and payment of schedule. We also address who would be entitled for the permanent custody of the children, whether visitation right can be given or not to be given. When the quashing of FIR, how and when and in modalities of return of the strident, and if number of other cases are pending, they're also required to be mentioned in the agreement, and when they are going to be withdrawn from the different courts, and ensure that at the time of drafting the agreement, we need to involve the lawyers also to avoid future confusion or any future controversy. Because the basic purpose of the mediation is that there should not be any future litigation. And then we also need to ensure whether parties have agreed or they have settled the dispute out of their free will without any force, fear, coercion, misrepresentation or any other external factor. The voluntariness of the settlement must be required to be assured or ascertained by the mediator or any other person who is conducting the matrimonial mediation. Right. Now, dear friends, what are the advantages of the matrimonial dispute, matrimonial mediation, the settlement of dispute by the process of mediation? It is having many advantages over the litigation. First, it is accessible to the parties. I said when I was talking about the definition of mediation, it is a voluntary process. It is party-centered negotiation. Party-centered negotiation. It is accessible to both the parties. And most important, it is voluntary. You know, judicial order, judicial judgment is always decided by the adjudicator. Whether it is liked by the parties or not liked by the parties, whether it is accepted by the parties or not accepted by the parties, it hardly matters. Ultimately, on the merits of the case, a dispute on adjudication is always decided by the arbiter or adjudicator. But in mediation, when we are particularly addressing the family dispute, we assure the voluntariness of the agreement. Why? Basic philosophy: if the conflict or dispute belongs to the parties, they must be responsible. They must be given a right and opportunity to resolve or to address the conflict in the manner they would like to address or they would like to resolve. Mediation process is facilitative. Facilitative मतलब कि मैं रास्ता दिखा रहा हूँ, रास्ते तक लेके जा रहा हूँ, पर मैं उनको मंजिल नहीं बता रहा कि what is your ultimately goal. I am just telling them the process, how the dispute can be resolved. I am just initiating the communication. I am just restoring the bargaining and negotiation. I am managing the impasse, also any deadlock between the parties. I am removing the obstacle in the settlement, but ultimately the settlement is to be brought up by the parties themselves because right of self-determination. The matrimonial proceedings are confidential in nature, just I have mentioned. It was also decided by the Honorable Supreme Court and I forget the name of the case, but it was a case which was originated from the one of the mediation center in your state. The Honorable Supreme Court, I remember the name of Honorable Judge, Honorable Mr. Justice decide that the mediation proceedings are confidential in nature. They cannot be disclosed at any form. Confidentiality is required to be maintained by the mediator as well as by the parties themselves. And that case was decided by Honorable Mr. Justice Markandeya Katcho. And role of the parties in mediation, particularly in the matrimonial dispute, is very positive in decision making. You know, I used to tell that mediation is a very democratic way of dispensation of justice. For the first time, the parties, they are given a right to participate in the decision making process, even the arbitration, even in the lok adalat, even in the conciliation. This right is not well recognized as it is recognized in the mediation. Ultimately, the parties are responsible for settlement. It is very private, informal, communicative. We address the long-term underlying interest, also very creative. And it's most important, any settlement, no appeal is provided, no revision is provided, it attains the finality. Once the settlement is accepted by the court, once the settlement is placed before you, first accept the settlement. After your acceptance, it is binding on the parties. There are a number of judicial decisions. I'm just referring. The Honorable Supreme Court already recognized in number of cases mediation as an effective method of resolution. It desired the parties to explore the possibility of mediation. It also mandated the family courts to make effort for mediation despite failure in conciliation. And I'm telling you, dear friends, after the Honorable Supreme Court judgment in Afghan case, every court is obliged to find out whether the case is suitable for ADR mechanism, including mediation or not, before framing of the issues. The family courts, they need to refer the dispute with the consent of the parties, although I just mentioned consent is not mandatory, but if you are referring the cases for mediation with the consent of the parties, it will give a very positive atmosphere for a mediator to address the dispute. Even the cases under Section 498A IPC can be referred to mediation if there is element of settlement. The Honorable Supreme Court is only talking about the possibility of the settlement. Whether case is actually settled or not, it hardly matters. But there should be the element or possibility of the settlement. The Honorable Supreme Court has stressed importance even on the pre-litigation mediation and its wide publicity. My humble request to all of you to kindly refer more and more cases, matrimonial dispute or other family dispute for mediation. In case Srinivas Rao versus D.A. Deepai's 2013 judgment, all of you must be knowing this judgment. The Honorable Supreme Court emphasized relevance of mediation in matrimonial dispute, including complaints under Section 406-498 A IPC. It was observed that parties one-to-one, when the parties, they are sitting in front of me and the lawyers and their advocate, they are taking the back chairs. When I talk to parties, their stories, matrimonial misery, they are full of pain, misunderstanding, sentiment, grief, anger, ego, emotions. And when we are addressing them to their satisfaction, I will give you one example. I was conducting one training program at the Jabalpur High Court for advocates and judicial officer. During that training program, one case was assigned to the participant and it was a matrimonial dispute. The two participants, one advocate and one judicial officer, they made effort for settlement between a pair which was living separately for last 5 years. Then with around 2 hours efforts, the husband and wife, they agreed to live together. When it was brought to the notice of families, they tried to touch the feet of the mediator. Then immediately I said out of my own emotion, today the life is not smiling on you, but life is saluting to both the parties because of their efforts, they could bring 2 families together which were separated for the last more than 5 years. Mediation, it saves legal cost, and I'm telling you, mediation is not a tool to delay adjudication. When you feel that this parties, they are using the mediation or any other ADR mechanism to delay the proceedings, judicial proceeding, they are not really and actually interested in the settlement, you can continue with the adjudication because mediation cannot be taken as a tool to delay the adjudication. I will give you what we have done in the mediation in our Delhi Mediation Center regarding mediation dispute, just giving you some empirical data. We are having 656 mediation center in Delhi at T. Sajari Court, Rohini Courts, Dwarka Courts, Patiala House Court, Karkaduma Courts and Saket Court. That we are having 6 district mediation center, and the Honorable Delhi High Court has given approval to establish mediation center at newly raised Rouse Avenue district courts. In around till 11th of January, since 2005, more than 73,000 cases have been referred for mediation, out of which we have settled 30,000 cases. These are the cases which were referred for mediation, around 30,000 cases. But more important is that around 22,000 cases which were not referred for mediation, which were also pending in the different court or at the threshold of their being filed in the court, they were also settled. So in this process, we have settled more than 50,000 matrimonial dispute, which includes maintenance cases under Section 125, petition for divorce, cases under Section 498A, 406 IPC, resolution of conjugal rights, domestic violence cases, and custody and guardianship cases. So mediation is a wonderful remedy. It's a new tool for bringing effective resolution or settlement between the parties, husband and wife, without undergoing the miseries and pain of litigation. After AFCON judgment and after the various judgment delivered by the Honorable Supreme Court, now duty is cast upon every court to make very positive effort for resolution of the dispute.
Thank you so much.
So, sir, this is my brief talk, the use and role of ADR, particularly mediation in matrimonial dispute. Sir, I started with perception. I take the parties to conflict, how the conflict can be managed, how the conflict can be resolved. Then what is mediation, use of mediation in particularly in matrimonial dispute. What are the factors responsible for matrimonial dispute, the judgments and the guidelines given by the Honorable Superior Courts in the field of matrimonial disputes. Sir, thank you, sir.
Thank you so much, Dr. Jain. You have given us a perspective which can ultimately, the mediation can play a role in settling the family court matters as such. What large number of matters have been settled? It is a good recipe, particularly in this domain for that matter. Justice Vikas Bahl has been waiting, and we are waiting and looking forward to his concluding remarks. May I request Justice Bahl to kindly make your concluding remarks.
Thank you, Balram sir. Thank you so much for making me a part of this wonderful workshop, which was really enriching. I think we all know that Mr. Gupta is one of the most revered educationists. And as far as I am concerned, I am very lucky. I am a part of the family, and we have always learned from whatever Mr. Gupta has done. He's worn so many hats. He's been a brilliant senior advocate. He's been one of the best teachers that we had in the Punjab University. And further, today, being in charge of the Chandigarh Judicial Academy, it's really a privilege to be associated with you, sir. And I must say that, Mr. Jain, possibly, yes, mediation is something which is generally known to all of us, but your study and your knowledge about the whole and also the practical experience that you've gone through was really enriching. And it was really a pleasure hearing you. Just to add and to conclude, what I would say that every single person who's a participant in the whole judicial process, I think can ultimately have a very, very strong mind to finally resolve the matter. What we need to understand is as to whether as a judge maybe or as a brilliant lawyer, whether we want to just get a matter decided or we want to get the dispute resolved. So if one matter comes up and we're able to finish the matter, maybe the lawyer will get his fee, the judge will get his point that he has decided a matter and have the satisfaction of having one matter decided. But when we're able to resolve the matter, resolve a dispute, I would, my understanding of it would be that these 6-7 peripheral matters, which would have arisen in case the dispute would have continued, apart from the person challenging the order passed by the judge, whether it's at the district level or at the trial court level or at the high court level, before the other further court, the appellate court. Apart from that aspect, the other peripheral, to exemplify, now in family disputes, as we understand, primarily it is the matrimonial dispute which is of grave concern. In family disputes, the moment there is a dispute between husband and wife, what we have seen now, what our experience is that apart from the FIR under 498A, there is a custody dispute, there is a complaint which is filed under the Domestic Violence Act, there is a dispute with respect to, there is a divorce petition normally filed, and then the maintenance proceedings. So resolving that one dispute between husband and wife would ultimately help us in resolving 6-7 cases and all the appellate proceedings or revisional proceedings arising from that proceedings. So I must say the importance of mediation is clear from that fact alone. Even regarding the other disputes between brothers, today what we have seen is whenever there is a dispute between brothers, there would be a suit for declaration in case there's a will, wanting a particular part of the property or wanting the whole of the property, and also would lead to some kind of an FR under 420, 467. And the dispute would continue for all life because these disputes do not end in a hurry. And there are appellate jurisdictions, there are then revisional jurisdictions, so all these continue. Now, so therefore, I would say, I would request that every person who is a part of the judicial process of adjudication must have it in the back of his mind that wherever they can resolve a dispute, wherever they get the opportunity, at whatever forum, at whatever stage, they must put their foot forward and they must help the parties in doing the same. I can, from whatever experience I have had, both as a lawyer and as a judge, I can share that with you. At least 3 outstanding examples that I have, which really helped the whole matter being resolved. I can share with all my brother colleagues and my seniors. I think the first and the most satisfying was one partition matter. It was between 2 brothers, and the partition matter had started around 20-25 years back. Before the amendments were made in the Partition Act, we all know that, you know, getting a partition in our country was not that easy. It would start from the first level of assistant collector. It would go up to the commissioner, and then it would come up to the financial commissioner, then come to the High Court, single bench, and then a division bench, etc. So, and in between, my experience was that at least there would be at least 7 or 8 remands. The commissioner would rather remand it on some kind of an objection taken, on a point taken. Now, this is one matter in which one brother fights against another brother, having a 100-acre land, saying that 50 acres belongs to me, please give me my 50 acres. They start contesting before the AC first grade. There is a particular partition which is done. An appeal is filed on a legal point. On a legal point, the matter is argued. And ultimately, after several remands and several proceedings take place, the matter comes before the High Court after 25 years of fighting. So when the matter comes up, and this is why I say it can be done at any stage, and I'm thankful to Mr. Jain that he's pointed out that the lawyers also have a very important role in the whole process. So once it comes up, it came to our office. One understood the legal issue involved, and the legal issue was a very, very debatable issue in favor of the petitioner. And only on the basis of the legal issue, one could have moved forward and one could have been very confident of a very positive result. But what came in our mind was that we must ask the client as to what is the real issue, what is the real problem. He is getting a particular piece of land. So we must know from him as to what is the real difficulty that is having in having that land. And sir, and Mr. Jain, believe you me, that we rang him up. We had to talk to the trial court lawyer. So they all suggested that Mr. Bahl, let's leave it. You got a good point, might as well argue. So I insisted. We got the man to our office. And he was an old, he had by that time become a little old. So I made a chart and showing him that this is the land that he's got. And I asked him sir, what is the problem with the land that you have got? You know what his answer was? His answer was that this is the land that I want. This is the land that I want. And I said, this is the land. No, he said, this is the land that I want. So I said, this is the land which has been given to you. For 25 years, he did not even know that what was he fighting for. Whatever land he wanted and he was in possession of, that was the land which was being given to him. And then immediately I told him and he started weeping. And he said, sir, it had happened that my brother used to tell me that, why are you fighting? At least tell me why, because there was no common platform. Possibly there was no common platform. Every lawyer felt that there was a legal argument to raise. They raised the legal argument and got a stay, and then ultimately the matter would have been decided one way or the other. So when I asked him, I told him, call up your brother now. He called up his brother, and he also came over, and they both wept for 1 hour. And the other brother said, I didn't even know what you're fighting for. I thought this is what you want and I'm giving it to you. So, and there are other peripheral matters which all ended. So this is, as Mr. Jain has very rightly said, at every single point, we all should think that we are a part of the whole system, and we must encourage, because yes, lawyers will earn, judges will get their points in different matters and ultimate whenever There's another example I must say, sir, that I was sitting in one court and there was a very, very brilliant honorable judge who's now in the Supreme Court. He was dealing with a matter. It was again between two brothers, and it was again, a substantial chunk of land was there. So the lawyer from the side of the appellant had very, very forceful arguments to give, including in the argument that how could have property been divided, which was agricultural property, before the civil court. So he had a very good legal argument to give. The honorable judge asked him only two things. He said, you both are brothers, land is owned by both of you. Both answered in the positive. The caveator counsel also answered in the positive. The appellant counsel also answered in the positive. So you both have to be given half the land. They both answered in the affirmative. He said the only thing that you can do now is either you make 2 blocks and the other person will choose it, or he will make 2 blocks and the other person will choose it. And then with the intervention, ultimately nobody had any answer, because yes, on title they were entitled, on everything. They went out and they came back. And I remember in that, then the counsel also, some intervention by the honorable judge. The understanding of the case was so well with the honorable judge that he knew what all was there. He knew the title, who's the owner of the land. As Mr. Jain said, that if you know your dispute well, you will be able to suggest, you will be able to say something which can ultimately resolve the whole thing. And I must thank Mr. Gupta. In fact, since the time that Mr. Gupta had mentioned that, this is the online workshop that we are holding. It's been a week or 10 days. At least in 2 matters, while adjudicating those 2 matters, this issue came in my mind. I was wanting to decide and adjudicate only. But this issue now as a judge, because on this side, it came in my mind. And the moment I put it to the counsels, in a flash, they were ready. And otherwise, the dispute was so substantial that it would have gone up to the Supreme Court. So they were ready in a flash. What I felt was that there is a lot to say from one side and there's a lot to say from the other side, but there is no forum. There is no forum. The moment your vent is out, the moment the vent of both the parties is out, and ultimately they feel that, the other side also, because the other side is also hearing, the other side has heard this is what my side of the game is, and the other side has also known that this is my side of the game. There has to be somebody who is wanting not just to decide cases, but solve the dispute. So the moment I suggested, and the moment in that, and this came in my mind, I am thankful to Mr. Gupta. I had gone with the idea of adjudicating. I had gone with the idea of finishing the matter because there was some urgency in those matters. And it came in my mind that this can surely be resolved. And I was surprised that the best of lawyers were appearing, taking a very hefty fee. The moment the suggestion came, the answer was in the positive. So now I know that those 2 disputes are heavy disputes. I'm hopeful that will be resolved. And hopefully I'm not saying too much, because there are 2-3 more things which are really, I feel some of the honorable judges have, conducted themselves in a manner that we want to imitate and we want to follow. And as Mr. Jain said, there was an honorable judge who's now also senior judge of this court. And at the stage of anticipatory bail, the question is at what stage we would want to really finish off the dispute. At the stage of anticipatory bail in a 498A, the honorable judge would ask both the parties as to what is their financial position, what is their claim, what are they wanting, what is the whole property that they have, how many children. Spend 20-25 minutes on an anticipatory bail, give his understanding suggestion. As Mr. Jain said, you can't enforce it, and then take suggestions and then pass some kind of an interim order granting stay arrest, explaining it to both of them that it's the best that this is resolved like this, and then referring them to a particular mediator at that local place. Assuming somebody's come from Karnal, maybe refer it to Karnal, an outstanding lawyer in Karnal, or both the lawyers would be made to sit, trial court lawyers would be made to sit. What was learned was 2 things. 1, matter resolved at the first stage. Secondly, the honorable judge was not wanting to just finish cases. He could have easily finished off an anticipatory bail in 2 minutes, earned the fact that he's got so much of disposal. Instead of that, he would put it for 6 months or 3 months, but then resolve the dispute. So my concluding remarks or my request to everybody who's a part of the system is, yes, we have statutory forums. We have CPC, Section 89 is there, Order 32A is there. We deal with all the suits with respect to families. And now that Family Act is there, we have Section 9. We have the Hindu Marriage Act in section 23. It has been made almost incumbent, mandatory on the courts to proceed in a manner that they should first try to resolve the matter and then adjudicate it. So therefore, now there's a mandate in the Acts itself. There is a requirement and there's a Supreme Court judgment. And interestingly, one more thing, while just preparing 5-7 minutes for this, what I had to say, Mr. Gupta, I can just share it. We always keep learning as we keep studying. So I got to know that in partition, as I've given you the example, sir, and Mr. Jain, there is an amendment in section 115. There is an amendment which has come in 2020, which says it is mandatory for the assistant collector to first get the matter resolved. So we have it in the Family Act, we have it in the Hindu Marriage Act, we have it in the CPC. Now we have it in the Partition Act also, the Punjab Land Avenue Act, section 115. So it's really wonderful. So the object of the act, the intent of the judgments of the Supreme Court, and this is it. And we should be feeling more satisfied the moment we are able to finish off one dispute than one case. And I am so thankful to the Chandigarh Judicial Academy, to Mr. Gupta, and to Mr. Jain, and to everybody who's participating, that you made me a part and you made me enriched today by all the wise words spoken. So one is really looking forward, to the next workshop now. Thank you so much, sir. Thank you so much, Mr. Jain. Thank you.
Thank you so much, Justice Bahl. I feel so good you have shared your experiences and strengthened this mediation process as such in that particular background. Also urged the judges at all levels to make an effort for mediation as such. Mediation doesn't result in winning or losing. It results in settlement as such, which is the ultimate in the entire process. I thank you so much for being a part of this particular workshop and look forward to your participation in future also. Dr. Jain, we are indebted to you and we look forward from you rich contribution and continue with the mediation process at the level at which you are going to be soon holding the court. Thank you so much.
Thank you.
Grateful.
Thank you, sir. Thank you.
Sir, thank you, sir. Thank you, sir.